SJC-13674, Commonwealth versus Jerome Q. Meade.
Attorney Sultan, whenever you're ready.
Good morning, Your Honors, and may it please the Court. This is Jerome Meade's direct appeal from his conviction of first-degree murder and related charges. The key evidence relied upon by the Commonwealth at trial included 3 videos which were found on Meade's cell phone. Those videos were clearly outside the scope of a warrant obtained by a Boston police detective to search Meade's phone solely for evidence relating to a subsequent unrelated offense. Therefore, under well-settled Massachusetts precedent, the burden was on the Commonwealth. The discovery and seizure of those videos were presumptively unreasonable, and the burden was on the Commonwealth to demonstrate that the seizure of those videos was lawful under an exception to the warrant requirement.
Why do you say the photographs from a week prior to this firearm offenses case were outside the scope of the search warrant?
Well, the warrant which was obtained by Detective Cavini on the 29th related solely to the September 24th firearms offense. And the Commonwealth has maintained throughout these proceedings that those videos, including the most important video showing the clothing that Meade was wearing the day before the September 16th, 2015 shooting, that those were outside. They were unrelated to the homicide. The Commonwealth concedes that. They conceded it in their brief. They say it's an unrelated offense. And they claim that these videos were discovered by the Commonwealth during a search for evidence relating to that September 24th unrelated offense. I mean, the facts really are undisputed. The first offense, crime number 1, was the shooting death of Louis Baden Maximo on September 16th. That's crime number 1. Crime number 2 occurred 8 days later when Meade was arrested following a car stop on Gaston Street in Boston, and his cell phone was seized, and he was charged with unrelated firearms offenses. And then Cavini, on September 29th, gets a warrant to search that phone solely for evidence relating to those September 24th firearms offenses. He gives the phone to Sergeant Detective Witherspoon, who does an extraction and gives the CD to Cavini. And sometime after that, some detective reviewing the extraction found those videos. Those facts are undisputed. And the Commonwealth, when the defendant filed a motion to suppress, claiming that those videos were outside the scope of the warrant, the Commonwealth, they didn't present any facts about who found the videos, when they were found, the circumstances under which they were found. The Commonwealth didn't ask for an evidentiary hearing. Meet its burden. Rather, all they did was assert over and over again that they were found inadvertently during a search of the extraction for evidence relating to crime number 2.
Do you disagree with the proposition that the plain view doctrine applies or can apply to the search of a phone pursuant to a warrant? In other words, you have a warrant that says you can search a phone for photos and files relating to, I'll just call it crime 2, and that while still within the scope of that warrant, the plain view doctrine may cover the discovery of photos or files that don't directly relate to crime 2? Do you disagree with that as a general proposition that the plain view doctrine could apply?
Well, that's a very important issue, and this court has repeatedly recognized in cases such as Doralis and Snow that it's questionable whether plain view should apply to digital searches, because if it does, then it essentially transforms every search of a digital device, like a cell phone, into a general search. So this court has repeatedly said in footnotes, going back more than 10 years now, well, this is really an issue, but the court has never addressed that issue squarely. Now, the court doesn't have to address that issue squarely in this case either, and the reason is because the Commonwealth did not prove through evidence that it did what is required for plain view, namely that it came across these videos inadvertently while looking for evidence of crime too. That's an evidentiary burden. They chose below not to present any evidence. They didn't ask for an evidentiary hearing. They did not meet their burden.
So your position really is that the judge, in finding that they had committed a clear error?
Well, yes, because
there was no evidence, no affidavit, no witness who said, I searched it for crime two, and I inadvertently came upon these videos.
That's exactly right, Your Honor. And the very first line of Judge Cowan's decision, which is after there was no evidentiary hearing, her first line says exactly that. These videos were found while they were looking for evidence of crime too. That only came out of the mouth of the prosecutor over and over and over again. But as Your Honor suggests, they never presented a scintilla of evidence supporting that.
So is
they didn't meet their evidentiary burden. The burden is on them. The seizure of this stuff that's beyond the scope of the warrant is presumptively unreasonable. The court has said that going back to Balicki in 2002. It's their burden, and they didn't meet their burden. So the decision denying the motion to suppress was clear error on that basis alone.
So why isn't the remedy here to conduct the required hearing so that facts can be found?
Well, I have two answers to that, Your Honor. Number one, we now know what did happen, okay? And this is important. We now know that Cavini, after he got that extraction CD from Witherspoon on September 29th, he made a copy of that CD, and he gave that copy to homicide detective.
Before you go into the facts, let me ask you this. I take it that no trial court judge has made findings concerning what happened as to this search other than Judge Cowan.
That's correct, Your Honor.
Okay, so, and just speaking for myself, I don't think that we can make those findings in the first instance, even looking at whatever the trial evidence is.
Well, I don't think the court has to make those findings. I think the court, I run in all the time. I come in here and appeal issues where defense counsel failed to meet a burden on a motion to suppress, and I lose. Here, it was their burden. They have to overcome the presumption that—
But doesn't someone need to make fact findings?
No, Your Honor, because the Commonwealth, they had every opportunity in response to the defendant's motion to suppress. They could have submitted affidavits from whoever found these videos, which I submit as Detective Bliss. They could have asked for an evidentiary hearing. They chose not to. They made that decision. They don't get a do-over. They don't get another chance.
This case is even further to your point. The defense counsel stood before the motion judge and said, we don't have an affidavit. The prosecutor's just making these representations. The judge said, go back, file your motion. That motion was filed, and again, there's no affidavit or testimony.
That's exactly right, Your Honor. I'm glad that you reminded me of that. That was the very first time the Commonwealth had said anything, made any factual representations about what happened. And they said this stuff was found inadvertently while we were looking for evidence of crime 2. And the very next day, I think it was September 24th, 2019, defense counsel moved to strike that filing and said these are just statements being made by the prosecutor. The prosecutor is not a witness. There's no affidavit. There's no evidence. And we have to have an evidentiary hearing, but that never happened. That's not, I mean, the Commonwealth should not get some benefit now when it made a strategic choice not to try to fulfill its burden to overcome the presumption of unreasonableness.
Counsel, I think your position is pretty clear that the Commonwealth didn't do what they were supposed to do. Let me ask you something downstream from there. So if the suppression order should have been granted, what do we do with the sufficiency question? Is that something that should be resolved now, or is that something that should be left for a retrial?
Well, of course, under this court's decisions, if you cutting out the videos, I don't get to cut them out as part of the sufficiency determination. I understand that. As far as what Your Honor is asking, I guess I submit that, and I think there are other cases where the court has dealt with sufficiency and still reversed and remanded for a new trial in order to avoid a double jeopardy problem. So I think the court should address that issue. Even if the court does what I'm asking you to do, which is to vacate and remand, not for a hearing, not for another chance for them to do what they chose not to do before, but for a new trial at which these videos and any other fruits of that search that was clearly outside the scope of the search warrant, any of those fruits should not be admissible. And if I may, Your Honor, I do want to get back just to what did happen here, because I think it is important. And I understand that this court has said over and over again, and I'm not even going to stand here and try to change the court's mind, that you don't consider trial evidence in whether or not Judge Cowan made a mistake, because that wasn't before her. Although I submit that that should not be a strict rule, that there should be cases where where there's a demonstration that casts grave doubt, I do think the court should have the flexibility to consider that. But even if it doesn't consider it on the suppression motion, and it doesn't have to, because it's clear that the Commonwealth did not meet its burden, under 33E, this court has an obligation to consider the whole case. And I think Gonzalez, which is a case that the Commonwealth cites, is directly on point. In Gonzalez, the defendant had moved to suppress statements. And then later at trial, there was evidence that the defendant, and the motion to suppress was denied. And then later at trial, there was evidence that, in fact, the defendant had asserted his Fifth Amendment privilege. And this court said, we're not going to consider that trial evidence on the motion to suppress. But the court went on to say, we are going to consider it under 33E. And the court did consider under 33E. And here, where we now know that Cavini made a copy, gave it to the homicide detective, and the homicide detective reviewed that extraction as part of his investigation into the homicide. We now know that that's what happened based on sworn testimony. The court cannot countenance that, allowing this conviction that was based on these videos to stand. The court under 33E, in order to prevent a miscarriage of justice, as a second independent ground for reversal, should grant relief.
Can I ask you a question? Does it matter here that the warrant that they obtained, which I know you're challenging the warrant, that the warrant was properly obtained for the other crime, for the firearm offenses?
I did make that argument.
Yes, but let's just assume that we disagree with that argument. So we assume the warrant was properly obtained for evidence of the firearm offenses. And it's a very broad warrant that essentially allows them to download the whole contents of the phone.
Without any temporal limits of any kind.
No limits, right? And so the police then have all of the contents of the phone downloaded from the phone, and they possess them in the police station. Does it matter then that in order to look at that with respect to the contents of the phone, they don't actually have to go back to the phone when they're investigating this homicide?
Well, that's a great question, Your Honor. And I think, this court's jurisprudence really over the last 20 years, from Bilicki in 2002 to Justice Wendland's seminal decision in Youssef, I think, as well as state and federal cases on digital searches that I cited in my brief, demonstrates that they have to get a separate warrant. They can't just have this bunch of stuff sitting somewhere, and then they can go back and look at it again for some other purpose later on. That's what happened in Bilicki with a video. That's what happened in Youssef with a video. And this court said that's a separate search for constitutional purposes, and you have to get a warrant. And I try to cite some really very interesting recent cases, one from the Michigan Supreme Court. I think the case is Hughes, a couple of federal cases where this issue has been squarely addressed, and these courts have uniformly said, this is a separate search, this is a separate invasion of privacy, you need a separate warrant. So they did need a separate warrant. Homicide Detective Bliss needed a warrant before he reviewed the CD that was handed to him by Detective Cavini. Yes, Your Honor.
Could you explain to me how would that work? Because I still get confused about that, because crime 2, warrants executed, download the entire phone. And now you said, and I don't necessarily disagree with you that you need a second warrant, but how would it work in practice? Because you're saying homicide detective in crime number 1, you shouldn't even be looking at the video.
That's right.
From crime number 2 that we have this war. So how would that work?
The way it works, Your Honor, I would submit is there's an application and an affidavit from someone who is looking at the phone for evidence of crime 2, who says, I was looking at this phone for evidence of crime 2, and I came upon a video which I believe, based on whatever, is relevant to crime 1. And that's an affidavit, a signed affidavit. And based on that affidavit, they can go back to a judge and say, we now want a warrant to search the phone for evidence of crime 1. But they need that and underpinning. They need some evidentiary basis. So that's how it could work.
I guess I know what you're saying, but let me just give you a hypothetical. Crime 2 is in a separate precinct. Crime 1 is in A1. Crime 2 is in C11. And so what you're saying is the investigating officer at C11 who's investigating crime 2, who might have zero information about the crime that happened in A1, is somehow supposed to now divine that I see this video, I see this clothing, I see this neon, all of the stuff that would, maybe particularly, give them a breadcrumb that this might be of evidentiary value to somebody else investigating crime 1.
Hunter's hypothetical shows exactly why their position is so ridiculous, because that's what they're kind of suggesting happened. But another way you could get second warrant is simply based on ordinary probable cause. By the time you do an investigation of the homicide of crime 1, and a few weeks after you after Cavini got his September 29th warrant for crime 2, at that point, you now have probable cause that, hypothetically, that Meade committed crime 1 and that evidence of crime 1 is on the phone. And you get, the same way you would have gotten a warrant to look for evidence of crime 1 in the first place. The standard way you get a warrant based on probable cause. There are multiple ways they could have gotten or sought.
I'm not trying to fight with you, but I'm still trying to. We have to give some guidance here.
Yes.
And you saw the same video I saw of crime 1. Okay. What would clue somebody in that the phone was of evidentiary value in seeing somebody get executed in that parking lot the way he was?
Well, nothing, Your Honor, except that in almost every homicide case that I've tried, once the Commonwealth has a suspect in mind, they get a warrant for the suspect's phone, and they invariably get it because they don't need a whole lot other than he's a suspect, he has a cell phone. There's not a whole lot, honestly, there's not a whole lot more that this court has required to get the warrant.
And there were 3 co-conspirators.
Sorry, Your Honor?
There were 3 co-conspirators involved, right? So
Didn't you say the
there's
text?
some evidence that there might be communication among the 3 or some probable cause that there.
Yeah, I mean, I think they could have done it the right way. They didn't. And this court has to, I mean, for all the reasons that an exclusionary rule exists, in order to prevent courts from being party to unlawful police conduct, in order to deter unlawful police conduct, for all of those reasons, relief should be granted. Mr. Meade should be given a new trial at which this evidence may not be admitted. Thank you, Your Honors.
Thank you very much. Good morning. May it please the court, Kenneth Steinfield for the Commonwealth. With me at the council table is Craig Iannini, the trial prosecutor in this case. I'd like to start with the fundamental rule here in the Commonwealth that the burden of proof to show that a search in the constitutional sense for evidence of the homicide was on the defendant. He had the burden.
I don't understand how the defendant didn't meet that burden. I read that repeatedly in your briefing, but there obviously was a search of the cell phone.
Yes, there definitely was a search of
So
the
it's
cell
on the Commonwealth to show that that search was reasonable or pursuant to the scope of the warrant that was issued to Keneally, I think, right?
Yes, and they have not shown that it was not because he only searched.
No. The defendant doesn't have to show that the search wasn't pursuant to that. I thought the Commonwealth had to show
Right.
it was
Right,
pursuant
but-
to that scope.
I'm sorry. He says throughout in his papers that there was a second subsequent search for evidence of the homicide. There was never a search for evidence of the homicide in this case. So for him, for his argument to be successful.
So your position on appeal after this trial, representing to this court that that Detective Bliss did not search the cell phone extraction?
That is correct.
That's your position?
Yes. What happened was, and I think the evidence supports it both implicitly and based on the representations by trial counsel, was that he was looking, Detective Kevaney was looking for evidence of the firearms offense and saw right away, he saw the Snapchat videos and he saw the clothing and he knew that that was connected to a homicide that was being investigated by
Where is that in the record? Where is the
Evidence.
evidence that Keneally saw that?
Well, it is
He was
in-
looking for crime too. Meaning the.
Sorry, he was not looking for crime.
September 24th.
No, he was not looking for it, but as soon as he saw it, he recognized it.
Where
It
is that in the
Well,
record?
it's both, it's in the statements by the prosecutor.
Okay, that's not evidence.
Right.
Yes.
It is also implicit or it is inferable from the fact that Kevaney gave the disc to the homicide detective who was investigating him. Why would he have done that? He didn't go to every other officer and say, hey,
You don't know
guys.
that? That's not in the record.
Well, but it seems just a very, very reasonable inference that he gave it to Detective Bliss, who was investigating a homicide, because he knew that in that homicide that Detective Bliss was investigating, the suspect was.
Shouldn't
wearing
that have
something
been
clothing.
presented to Judge Cowan at the motion to suppress? All of that you just laid out as to how it is that the detectives or the investigating officers of the shooting came across this evidence that was extracted from the phone pursuant to a search warrant in crime number 2.
Ideally, yes. The judge, however, accepted the representations of the prosecutor. And
But
I
as
want to
you
make
just
one
said,
Really
point.
that's-
erroneous
yeah.
because that's not evidence.
That's not evidence.
And
Well-
this theory that you're spinning now that it was implicit that that's what happened is
Well-
not supported also by the evidence.
Well, it is undisputed that he gave the disc to Detective Bliss
Right.
afterwards.
And I
after
think that
reviewing-
that is an undisputed problem for the Commonwealth.
Well, I'm not sure how that's a problem for the Commonwealth.
Because
He
the
gave it to
search
him.
warrant was for crime 2. And now the detective who's searching for crime 1 is searching that phone for crime 1.
Yes, and he
That's
sees
a
evidence.
problem.
This is the but in plain view, the third
So
factor
you
is-
know, cell phones are different,
Yes, of course.
right? There's all sorts of information that one carries on cell phones.
Yes.
And just because for crime 2, the officers have a search warrant to search that cell phone, and in order to preserve the data in its pristine state, they extract it from the cell phone, doesn't give the officers the right to search anything in that extraction.
Absolutely right. They only search for what was, and the only thing that they
They only
found,
search for, finish that thought,
they only search for evidence of the firearms offenses.
crime 2.
Right, crime 2. And they found evidence that was connected to the earlier
But
offense
that
1.
statement is entirely not supported in the record.
Well, there's nothing under oath. It's not unsupported. There are statements, and I believe there are cases that a judge can accept a representation from counsel, especially, my premise is that the defendant had the burden to show that a search occurred.
But he knows,
Because
we
there's-
know that there's a search. There's been a search of the cell phone.
Right, but for evidence, he has to show that there was a search for evidence of the homicide.
No, he has to show that there has been a search. The Commonwealth's burden is then to say it was pursuant to the search warrant issued properly for crime 2.
Yes,
Yes. And that's how we found these videos.
yes.
Yes. And that part, that's how we found those videos. There's no evidence of that.
Well, we disagree, and of course, the record shows what it shows, but I
Well,
don't
I
know,
understand
Judge.
it shows what it shows, and I looked at it, and there's no affidavit, there's no witness
There is.
saying, I found this. There's not Detective Canale saying, I found this pursuant to, I
Absolutely
work
true.
on crime 2.
He did not testify, but he was not asked to testify, and I would like to focus in on why there was no evidence.
Why was he not asked to testify if it's the Commonwealth's burden to show that it was found within the scope of the search warrant?
Well, the defendant didn't ask for an evidentiary hearing, and we didn't have that burden. And
What's your best proposition for the Commonwealth doesn't need to show that a search is reasonable?
well, of course it does. Once the defendant has shown, I don't have much more to say than I believe that they had the burden to show that a second search occurred for evidence of a homicide. And based on that premise, I'd like to go over.
But what is your best authority for the fact that the defendant has to show not only that there was a search, but there was a specific search for a second search, as you call it,
Right.
for evidence of a homicide?
I think that's exactly what occurred in Yusuf. He's going through the body cam footage, looking for evidence that he's no idea whether or not it's going to be there of firearms offenses when he sees the curtains. That's a separate search for evidence of a separate crime, as to which there was no warrant. Here, there was no analogous search, facts that are analogous to that. Because when Detective Bliss got the disc from Detective Cavani, he got it because there was evidence on it linking, and there's no evidence.
So tell me this, why isn't another inference we can draw that in fact Bliss is the person that found the videos, the following? If Canale had found the videos on that cell phone extraction that are at issue here, why did Canale not just send him the videos? Why did he send him the entire phone extraction CD?
Because he had it on a disc, and I think it's a reasonable inference that it was just to facilitate his transference. He was not obligated to segregate.
No, but
that.
you're asking me to make
Right.
inferences that you call reasonable.
Yes.
And I'm suggesting that there are alternative inferences, and where that's the Commonwealth's burden. I don't understand
but-
why we
but
can
the-
make it on your
The
favor.
only evidence that was used at trial was those things. There's no evidence that Detective Bliss did a further search for other stuff, and even if he had, it would not have mattered because nothing else was introduced at trial against the defendant.
Okay.
So the fact that just for convenience or for ease, he gave him a full disc does not show that Detective Bliss did anything other than look at those Snapchat files that showed the clear evidence which linked him to the murder. As to the lack of an
Attorneys-
evidentiary here.
Excuse me, if you wouldn't mind, assume we were to determine that there was an infirm evidentiary basis for the judge's findings on the motion to suppress. Could you please address the issue of the proper remedy?
Well, I think that it would be a remand for an evidentiary hearing to have the officers testify under oath one way.
Why doesn't that result in an unfair, second bite at the apple or for the Commonwealth?
Well, the Commonwealth, in good faith, provided the court with information, and the judge did not say, "Well, I don't have any."
I know.
evidence
So
in
is
front
it?
of me
You know,
under oath."
we don't really need to parse out, do we, whether it was the Commonwealth's fault or error or the judge's error? There was an error.
Of course.
Because I know you're not going to concede that, but
No, I don't.
assume that we were to conclude that there was an error to make factual findings in this case, given the record that was before the judge, which wasn't a record, which was essentially like a trial by representation, which we have in other contexts criticized, right? So, so why should we, in these circumstances, allow the Commonwealth to essentially do something in another way, present the hearing or conduct a hearing in another way? Assume we're operating under a 33E rubric,
Sure.
as your brother suggests. That's my question.
This court has in the past remanded post-conviction for evidentiary hearings on things. These are very important things that are very difficult. Long after the fact, it once remanded for a competency determination, a post-trial determination of the defendant's pretrial competency, which is a very sort of complicated thing to do after the fact. And I think that this is analogous here. We're all searching for justice, including under 33E. And I think both sides, the Commonwealth and the people whom it represents and the defendant, have a right to a fair trial and to justice. And here, where I don't think that would be a difficult matter, it would obviously put the defendant through something else after he's been through.
Is there a case, though, where the defendant squarely raised the issue? This is not a situation of ineffective assistance of counsel where, something wasn't in front of the court and we develop in our 33E review a concern and so we send it back for fact finding. This is a situation where the defendant said, move to strike the response.
That's exactly what I wanted to get to. Here's how that came about. I'll start by saying defense counsel never asked Judge Cowan for to strike anything or for an evidentiary hearing. The issue was first raised in a supplemental Franks memo by the defendant. And there was a hearing in front of Judge Sullivan to talk about the Franks hearing. Defense counsel raised this claim right now, asked to strike the Commonwealth's representation and asked for an evidentiary hearing. Judge Cowan said, that issue is not before me. File a motion. More than a year later, the defendant, represented by new counsel, filed that motion. That motion did not ask for an evidentiary hearing. That motion did not complain about the representations by the trial ADA, did not say that it was inadequate, did not say that it was insufficient, and therefore, Judge Cowan had no notice at all that there was an issue about the evidence because it was never brought to her attention. The request to strike and for an evidentiary was made at a hearing on something else, and it was a judgment a year later dealing with it. So it is not fair to say that it was before Judge Cowan, that she never rejected a request for an evidentiary hearing or for further evidence because she never asked for one.
I think your brief concedes that you're not claiming a waiver here because what the motion that second attorney did file squarely raises the issue that's before us today, does it not?
Yes, it does.
And so it's a little odd to me that the briefing in this case does not tee up the issue of should there have been an evidentiary hearing. Everyone's leaping to the merits. And it seems to me that the essence of your argument is that the defendant's motion failed to raise a substantial issue requiring a hearing, right? You're saying Judge Cowan, it was fine for Judge Cowan to just deny this without a hearing. Is that effectively
Well, it
your
was
position?
not asked for, so we don't really take a position as to that. Was what the defendant wanted. The defendant filed his motion, didn't ask for an evidentiary hearing, had an argument where he made his arguments, the Commonwealth filed his opposition, and the judge decided. So I think that was enough in this case based on what the defendant asked for. I don't think there was any misconduct or any, what Your Honor just said, I think the way it happened is perfectly reasonable. And of course, as I said earlier, ideally there would have been an evidentiary, but the defense lawyer never asked for it from Judge Cowan. So if the court is, of course, thinks that she erred when she accepted those representations, then I think it should.
But do you have case law for the proposition that if a defendant's motion to suppress does raise a substantial issue and the burden is on the Commonwealth, that the Commonwealth, because there was a search and there is a warrant and the search is for a crime that's different from the warrant, that the defendant's claim is, I suppose you're saying, waived because the defendant didn't ask for a hearing for the Commonwealth to make its case?
Well, I don't say that. I say that the evidence that was put before the judge, and I use the term evidence lightly, the representations made were sufficient both for defense counsel and for the judge at the time. So there was an issue raised by the motion that was substantial, but there was no need, no one sought an evidentiary hearing. So I'm not saying that it did not raise a substantial issue because it clearly did, but there was no need for an evidentiary hearing on that.
You're saying there's no need for an evidentiary hearing because it was so obvious that this was found in plain view?
No, because there were the representations of counsel and they didn't ask for it. I mean, that's my argument. Either this court agrees with it or not. I don't have a whole lot to add to that, and I can understand why this court has a problem with it. You know, it as I said, would have been ideal to have a hearing, but the lack of one, I don't think means that the court should overturn this conviction or send it back for an evidentiary hearing. But if it does either of those, I'd ask that it do the latter. And here, I think it's important for the court to keep in mind that there was only one entry into his phone. There was only one intrusion, one investigatory review, which is a phrase that this court uses.
That seems to me, perhaps true, but an incomplete statement. So if the intrusion you mean is a single extraction, it looks like that was the case. There was just a single extraction. But if the intrusion is the search of the information on the phone, then it's not clear to me that there was only one intrusion.
Well, there's no evidence in the suppression record that Detective Bliss...
There's no evidence in the suppression record at all. There's only information.
I'm sorry to interrupt, Your Honor.
No, not at all.
Unpleasant habit of mine that
I have that one too, so.
I'm sorry.
No, but even under the Commonwealth's theory, there are two intrusions in the sense that there are two lookings into the contents of the phone. It may have been only through the disk, but it was still into the contents of the phone.
Well, but it was like, suppose they had seized the sweatshirt and the shirt physically from the defendant, either when they arrested him and then they handed the physical shirt and the sweatshirt to Detective Bliss and said, here.
That would be, I'm sorry to interrupt you, I have a bad habit as well. And we can all seek therapy later. But
I'm too far gone for that.
But there's two problems with that analogy. One, physical evidence is entirely different than digital evidence, especially cell phones. And two, if in fact the sweatshirt, the videos, had been found by Detective Keneally, and now I've forgotten his name, but if it had been found by that detective and given to Detective Bliss, then maybe you could have one search. But clearly, Bliss, if in fact he got that CD, he had to search that CD in order to get the videos. So he did a second search. There's your evidence of the second search.
Well, we disagree about that's a search. He was told that they were on there.
And
so
he went and he found them.
He looked on it too. That's not, he's not doing an investigatory review for anything. He is looking at what has been pointed out to him, which is very different. He didn't look through the whole phone for anything. Well, there's nothing that was admitted at trial against him. All we have were the Snapchat videos. So even if he had, then it wouldn't matter because it did not prejudice the defendant at all.
No, but So let's just say, for my purposes of my hypothetical,
Sure.
that the cell phone and the cell phone extraction, those are equivalent, right? So there is search for crime 2 by Detective Cavani. And then there is a second search by Bliss for the videos of that extraction.
Well, I strongly disagree that there was a second search by detectives.
How did he find them?
I think he was
How did he find them?
Pardon me? He was
How did
told
he
they were
find-
there.
He was told they were there, and then what did he do?
We don't know, but
We don't know, but we know he found them. And what's
found them
that
'cause he
called?
was
When you
told-
look for something in a CD and you find something, don't we call that a search?
well, no, he didn't. It doesn't make sense. He didn't have to look for it. He knew where it was. So all he's doing is extracting from that what he is told is there. It is, and I understand, of course, the difference between physical objects and a cell phone. But by analogy, I think it is very similar, especially in this case when we're talking about a very narrow window of time. And of course, the ultimate concern is how many times are there intrusions on the defendant's privacy. And here, the Commonwealth states that there was only one. And they found incriminating evidence that they knew was incriminating under the third prong that was obviously apparent based on information they had about another crime. And all they did was give that evidence to the detective who was investigating the homicide. And I don't think that that was a violation of the defendant's constitutional rights. And I think it was perfectly good police work for them to then to use just those Snapchat videos, which had previously been found at trial against the defendant.
Thank you very much, and thank you for tolerating my intrusion.